Good evening, everybody. Hope you're all doing well. Today is Wednesday, November 5th, 2025. We are just a few weeks away from the end of the year. And I think 2026 is going to be a very interesting year in the Social Security world. If you haven't already heard this, there's a lot of rumors going around about some pretty major changes that may be made in Social Security. Specifically, the talk is that age will be reduced or eliminated as a factor. In particular, the grid rules right now, which basically say that at age 50, even if you could do sit down or sedentary work, you can be found disabled. At age 55, even if you could do light work is defined as standing and walking 6 hours a day, lifting 20 pounds occasional. They're talking about getting rid of that. I've talked to a lot of my colleagues, and the general sense is that we have not seen anything come out formally. So right now, it's just a lot of conjecture. That's number one. Number two is that if it does come out, it could be changed. I mean, there could be a proposal. Congress could change it. There's going to be lawsuits because there are certain things that Social Security can change administratively as an agency, and some things that Congress has to get into. I know one thing that has been talked about a lot is that Social Security is really struggling with the resources they use to identify jobs and job numbers. They still used in part a resource called the Dictionary of Occupational Titles, or occupationalinfo.org if you want to look at it. This is a Department of Labor publication that was last updated in, I think, the early 1990s, and there are jobs in there that clearly do not exist anymore. Other jobs that exist, but in a very different way. Example, I had a hearing recently where my client was employed by a hyperbaric chamber company or clinic. Well, there was, I think, no such thing, or certainly not as a clinic back in 1990. So Social Security analogized it to being, working in a tanning salon. Well, it's a very different thing. So the point is that the Dictionary of Occupational Titles is very outdated. Information is not very accurate. The issue in the Social Security world is that vocational witnesses are obligated to provide evidence, testimony about jobs that you might be able to do. And if they use the Dictionary of Occupational Titles, jobs that existed in 1990 don't exist the same way in 2025. That's one issue. The second issue is that the job numbers, nobody really knows how many jobs exist for any particular occupation. The DOT is not being used anymore. There's different other resources that do not exactly correspond to the DOT categories. So vocational witnesses will extrapolate. So let's say, for example, there are 10 DOT codes in one, something called SOC code, or I think selected occupational characteristics. So some vocational witnesses will say, well, let's take the SOC number, divide by 10. Well, that doesn't work because, you may have, 90% of the jobs maybe in one code as opposed to, evenly divided. My point here is that if they make a major change, up until this point, the courts have been kind of deferential to Social Security in allowing them to use these outdated resources and also the quote unquote expertise of vocational witnesses. My guess would be if they change the rules to make it a lot more difficult, the courts are going to be probably a little more open to challenges to vocational testimony. And in particular, challenges that say that the resources used by vocational witnesses are inherently inaccurate. That argument has not really held water up until this point, but judges tend to look at things kind of holistically, and there's inevitably going to be a judge who's going to look at this and say, well, they changed the rules, made it a lot tighter. We're going to also make it a lot tighter for them to justify the statistics that they're using. So there's going to be a give and take with all that. If it happens, my guess would be it'll be effective sometime mid to late 2026. What I would say is, if you're on the fence, if you're watching this and you're on the fence about filing for disability, I'd go ahead and do it, because you want to be grandfathered. I wouldn't say grandfathered in. You want to be in the system, because what will happen is there'll be a certain date. They'll say that, cases after this date are going to be subject to the new rules. Cases filed before this date will be subject to the old rules. And I think the old rules, no matter what the new rules are, the old rules will be more beneficial to you. So if you're on the fence, or you know somebody who's kind of on the fence about whether to file, this would be a good time to really think about, maybe this is a good time to file. So, for whatever that's worth, that's my take on that. But I do think we'll see some changes, probably. Again, I've done this a long time, and every once in a while you hear about these major changes coming and nothing ever happens. But I do think there'll be some change. There is certainly a sense in Congress and in the executive branch that Social Security is, believe it or not, they think it's too easy to win, which that's not been my experience at all. So this is an opportunity they're going to try to take advantage of. I think what drives this in many ways is the trust funds that fund Social Security disability are running out of money. The only way to solve that is to raise taxes or change the wage base. Politicians don't like to do that. And, Social Security disability is not like Social Security retirement. There's no real lobbying organization. Retirement has the AARP. There's nothing like that for disability. So you're dealing with, basically a program that there's really not a defined constituency for. So it's easy to go after them. I mean, they wouldn't want to go after seniors because AARP gets the seniors out to vote. There's nothing equivalent to that for disabled people. So it's an easy target. So we'll see what happens. I'll keep you posted. But I do think that we need to be on alert for that. I'll most likely put something out on my blog, maybe a sample letter or two that you could send to your congressperson or senator, basically saying, that this notion that Social Security is too easy. One of the other things they're arguing is that, because there's a lot more jobs that involve, computers and inside work and service type of jobs, that people can do them without, if they've just done physical work. And again, that just falls apart. I mean, my opinion is, many people who are in their 50s and 60s, maybe grew up at the beginning of when computers became a big thing. But, I know a lot of people that are, early mid 50s, early 60s, who are not computer literate at all. And if you've done a job where you've been doing construction work or warehouse work or physical type of labor, the idea that you could migrate to a computer type of job, I think, is just absurd. But that's the logic that jobs are more available. So I don't think any of that holds water in my mind, in my experience. And I think I've said this before, that in my experience, there are far more people who get turned down for disability that deserve it than the other way around. So I think that's kind of crazy. I do think that it will continue to be increasingly difficult for people in their 40s, 30s, and 40s to get approved unless they have overwhelming medical evidence. My guess would be people in their, especially mid 50s, 55 and up. I don't think it's going to make that much of a difference, would be my guess. But, we'll see. Time will tell. I've learned over the years not to get too caught up in all this until something is actually on the table. So we shall see. We shall see. But, if anybody hears about anything or has any questions about it, again, I'll do my best to answer. But right now, there's just a lot of unknowns. Whoever's making these changes or talking about putting these out has not done anything yet. So, all right, let's go to the questions. Joe, one of my loyal listeners, says, good evening. The Appeals Council made a decision a month ago, but he's not heard anything. So, basically, and I won't talk about Joe's case in particular because he has filled me in a little bit on it. But, when you file an appeal to the Appeals Council and you look on your My Social Security statement and you see a decision has been made, normally they mail it out and you get it within 5 to 7 days. If it has been a month, that says to me it may be lost. So I think what I would tell you, Joe, is to get on the phone, call the Appeals Council if you can get through. That's going to be a real challenge. I would also reach out to your U.S. Senator representative and ask them for help, because if you know that they made a decision and it's been a month ago, you've not received it, the problem is it's lost in the mail. You may never get it. And, the 60 days to file a federal court action will be gone. And it's really hard to undo that. So I would say be proactive in trying to find out what's going on. Again, you can call, fax, write the appeals counsel, ask for, information about your case. But I would also take the political route and contact your senator representative, because they may be able to assist with some of this as well. So anyway, I'm going to try to get myself a little more centered here. There we go. Okay. SA says, why does Social Security contracted consultative doctors have the applicant stand on one foot, specifically concerning low back pain, lumbar radiculopathy? What are they testing? What if a patient can do a few repetitions before experiencing radiculopathy pain? Does the C examiner only have them do one leg stance once? How does this convey the patient's pain severity? Big picture is there are a number of tests that doctors do to evaluate your, damage to your nerves, your strength. And off the top of my head, I don't know all of them, but you could look up, just go to Google and type in, tests doctors use to evaluate radiculopathy or back pain. And obviously that's one of them. Standing on one leg in terms of strength, in terms of balance and things like that. I don't know what that's called, but you'll see that certain tests, it doesn't require a long time. And these are just tests that they use. They can make a conclusion out of it. Of course, it does not reflect the reality of what you've been living with for month after month. And this is why, statements and observations from your own treating doctors is a lot more valuable than a one-time evaluation from a consultative doctor. But Social Security, in its wisdom, believes that the one-time visit can offer some useful information. I'm not so sure that it really does, but you will see doctors making conclusions, issuing conclusions about the level of your pain, the functional impairment, with some of these very, very superficial kind of tests. And Social Security can use those. So this is why you should never rely on a consultative evaluation to hopefully to get you to the finish line of winning a disability case. Your own doctor's opinion is going to be a lot more valuable. Is there validity to some of these tests? Yes, you should try to do the best you can, because some of the tests are there to determine whether you're malingering or you have secondary gain. But yes, these tests are legitimate tests, but do they give you any sense of your problem longitudinal over a long period of time? No. But they do, for that particular point in time, will say this is your capacity based on your ability to do these things. Are these tests foolproof? No. Are some of them perhaps outdated and don't really reflect, the reality, and maybe there are better tests that can be used? You'd be surprised. In medicine, a lot of things we just assume, doctors do these kind of tests. They take, I'll give you an example. Some of you have heard this, the thermometer, a 98.5 is supposed to be a normal temperature. Well, the reality is, some people, normal is 97. Some people it's 99. It just depends on the individual, but it's sort of written in stone. Well, 98.5 is the average temperature for a human being. Well, a lot of this stuff is it's because it's been a long time. People assume that this is accurate. Again, some of these tests that they do, when a doctor, taps on your knee to see a reaction. Okay, what is that telling them? That when he tapped on your knee, there's a reaction? Does that mean, should that have any impact, or should that give us information about your capacity to walk or lift or stand? I don't think so. But again, these are just kind of standard tests that doctors do. So to answer your question, SA, the doctors go through kind of a standard litany of tests. I think that, if those tests come back a certain way, that should not be seen as definitive conclusions about what your capacity is. But you have the requirement, you have the obligation to get statements and reports from your own doctors that discuss the reality of what you've been dealing with for long, for week after week, month after month. Because the consultative doctors, in general, are going to be very superficial. Many of these doctors are insurance. They do a lot of work for insurance companies. So their bias is to minimize impairments as well. Look, I've been in hearings where the judge will call a medical expert, and this is a doctor who testifies. A lot of times they're retired doctors. They testify at hearings for various things, not just Social Security. And I've seen doctors in these in hearings, they will go into exhaustive detail about what they think a person's functioning could be. Their what they call the residual functional capacity, their capacity to lift and stand and walk and all that kind of stuff, based on a review of the record. Never met the person, never laid eyes on the person, but they review the record, and they're talking definitively about this is what they can do. And of course, my questions would be, isn't it true, doctor, that a person's experience of pain is unique to that person? You have a person with a very high pain tolerance, person with a low pain tolerance. If you have a person with a low pain tolerance, is it not possible that the level of pain you see from the record could be disabling? Well, yeah, it could be. Isn't it true that a person who has a bulging disc, that some people that may be a minor inconvenience, other people it could be put them on their back? Yes. I mean, everybody's different, and that, again, Social Security went away from the treating source rule for some ridiculous. Well, I know why, but it's ridiculous that they've gone away from it, and they tend to rely on the one-time evaluations by consultative doctors or the reviews by non-examining doctors, and it's a really horrible shortcut. And yeah, you can appeal it, you can argue that it's not applicable, but the courts have given Social Security a certain amount of leeway, because look, the reality is, unless the judge came to your house and spent 2 or 3 weeks with you, he or she is not going to really know what's going on with you. They're going to have to rely on the records, and medical records are many times flawed. Examples I see, doctors will do a history or a summary when you first meet with them, and then that they just copy and paste. And so the next 3 years of records, the first paragraph is the same one they wrote 3 years ago. It's not accurate anymore, but they don't ever get around to changing it. You walk into the doctor, how are you doing today, Mr. Smith? I'm doing okay. Claimant said he was doing fine, no complaints. Well, he may just have said, I'm doing okay as a figure of speech, but that's what the doctor put down. You have a doctor that did a surgery, a laminectomy, a fusion, something serious, and you come to see the doctor 3 months out. How are you doing? Well, a little sore, but I'm hanging in there. Patient reports he's doing well after surgery. Obviously the doctor did the surgery. He or she wants it to work out, and so they don't want to get sued either. So they put the positive spin on it. These are all things that happen in real life, but Social Security judges, all they see is claimant says he's doing well. So you have to. That's really a part of the job of an attorney, is we have to rebut some of that and show this is really not the case. That when I told them that, I was being polite. That's why I tell my clients, if you're not doing well, write the doctor an email, write them a letter, and get that in the record that, no, I'm not doing all that well. That's why I think you should always subscribe to the portals of your doctors, read the medical records, and if they say something inaccurate, respond to it in writing so that it's in the record, because otherwise it just becomes part of the record and judges will just believe it. So I hope that answered your question, S.A., but medical reporting is not objective. It's very subjective, and it can be inaccurate. I've seen it that way many, many times. Okay. I'm 64, says Viv. In February, filed for SSD in February of 24. Initial denial April 25. So you waited over a year for denial. Now in reconsideration, filling out a new function report. The big change, I'm doing caregiving for my husband because of cancer treatment. Do I say anything about the caregiving? The new function report? His treatment will be complete in January. I take him to and from appointments, help addressing meds and medical advocacy. All right, so I think that, the accurate thing, and again, you're asking about how to complete the form. I think that, you would need to put, to be accurate, that for whatever period of time through the time you're going to stop, that you are doing more driving, but you need to describe very particularly what you're doing in terms of caretaking, what they're going to be focused on, because there are jobs out there being a caretaker, a sitter for a person who's going through illness. Now, is it physical? Are you having to move him, to roll him over, to get him out of bed, to bathe him? Or are you basically, is he mobile and you're taking him to and from the doctor, changing some dressings? I think you want to be very, very specific about what you do on a day-to-day basis and how long you've done it. If you did it for 3 months, you could, even say that you did that, we can call it a quote unsuccessful work attempt, that you did it because you had to do it, it was your husband, but that it was really, really creating a big issue for you. If you have trouble doing the job, make notes about the trouble you're doing. If you need to bring in help, either a third party or one of your kids or something like that, make note of that. But I think it is relevant and it does reflect to some degree your capacity. So I think you want to be accurate. What I would probably tell you to do would be, emphasize the difficulty if there is difficulty. And then after treatment is over, and hopefully your husband's in long-term remission, submit another one of those forms in, say, late January, or after you finish caretaking. And even if they haven't asked for it, submit another one anyway. And say, after this, I really, went out of my way. I did things beyond what I really probably should have done, but I did it because it's my husband. I could have not done this for a third party. I had opportunities to take breaks when I needed to take breaks. I got help from people. You want to draw a distinction how this was not like it would be if you were doing as a job. For example, if let's say you were doing, I'm just, again, let's say giving a sponge bath, and a particular day on a Tuesday, you were having a really bad day and you said, let's just delay this till Wednesday or Thursday. That's not something you could do if you're working for a home healthcare company. So again, things like that, if you had to delay them, I would make notes of that. Realize that in Social Security, you're trying to paint a picture. And, what you're trying to paint a picture here of is a dynamic scenario where, every day is not the same. And, if you did something for 3 or 4 months because it was your husband and you had to do it, and maybe you worked beyond what your, real capacity was, I think, most judges would say, okay, I understand. This is her husband. He did that. But if it's, only for a few months and then you get back to more of a normal routine, fill out another one of the forms. You can get them online and, and make an update to the form. But yeah, I do think you need to reveal that. Okay. Okay. So, all right, Essay, let's get back to your question here. Essay's question was about consultative evaluations and the tests the doctors give. And what we're saying here is that some of the tests, let's say standing on one leg, he could do, but needed support, needed to hold on to things. This is where it might be useful after the consultative report to write kind of your own summary of what happened and how long the test took and difficulty you had doing them. And that way, whatever the test result is, and if you have an attorney, ask your attorney to get your copy of it, you can post, I don't want to call it a rebuttal, but you can post an explanation. The doctor said I was able to do this standing one leg test. Your comment would be, yes, it is true, I did that. However, he did not report that I had to hold on to bars. I only did it for 10 seconds, and it was not something I could do. I could repeat, whatever it may be. But I think you could, you always have the opportunity to fill in an explanation. There's a form, SSA 795. You can download that. You can type it in online, where you can really explain in more detail some of the things that happened. Judges can decide whether they want to give it credibility or not. But I think that, the theme here, if you want to call it that, is that just because it's written by a doctor doesn't mean it's 100% right. And if you have the ability to go in there and make some updates and changes and explanation, I would definitely do that. RD says, DDS is asking me to fill out my second functional report in the appeal process. It says normal. Yes, it is normal. They feel like reconsideration. They're reviewing everything again, and they want to see, is anything really changed? I think there's also an element of giving you busy work so that you won't be calling and asking for status reports. But yes, typically you see one at initial, you see one at recon. And if things have changed, make note that they've changed. If they haven't changed, you still want to fill it out. I wouldn't just say nothing has changed, see my prior report. I've seen people do that. Don't do that. You want to fill it out. But just, again, be very specific when you fill these forms out. Don't say things like not very much, not very far. You want to talk about 10 minutes, 15 minutes, 30 feet, whatever it may be. You want to be very, very specific about that. G. Andrews says, how do I receive my meds every month if I'm visiting my niece in another state? Is it okay to have two addresses? I think that's really something between you and your doctor. You need to let your doctor know you're going to be at a different address, for a month or two or a week or whatever it may be. I think it would be better to have your pharmacy in one place, ideally where you live, and try to get enough refills or enough, pills or whatever the medicine is that could last you the month. I think, if you ask your doctor to authorize a prescription, especially pain prescriptions in two different states, you may get some pushback. Doctors, especially when it comes to pain medications, are very, very concerned about, not providing people extra pain medications. They can get into a lot of trouble for that. So I think that, you probably want to talk to your doctor about, what you're doing. But if you have the simple thing would be, if you go once every month for a week, instead of getting your prescription refilled every 2 weeks, see if you can arrange to get it filled once a month. I think that'd be a better way to go but otherwise talk to your doctor. That's really more of a doctor-patient issue. But yeah, I think with pain medication in particular, it's going to be difficult to convince a doctor to give you two different pharmacy prescriptions for two different pharmacies. And yeah, I think that, well, I'll just leave it at that. All right, Christy says, Solokowski, please yes, thank you, Christy. I appreciate that. Jen is our paralegal. Thank you, Jen, for tuning in. Good to see you here. Cynthia, one of our clients, good evening. How are you doing? Bama DRB, good evening. Hello, Bama. How are you doing? RD says hello from California. Hello, RD. Hope you're doing well. Angie, how long do you see it's taking the appeals council to make a decision? Do they strictly just look at the application of SSA law? Would the audio cutout issues be sufficient to remand? Well, first of all, I'm seeing it take, longer. And again, this may have something to do with the shutdown, 8 to 12 months. There are certain issues, certain mistakes in a decision that are considered harmless error, some that are considered harmful error. If the audio cut out, I've seen cases where cases were remanded because the audio was not something they could listen to. If, however, there were issues discussed in the part of the audio that is there that the judge relied on to deny your case, then the part that's missing may be deemed not relevant. Now, look, I'll tell you, I had a hearing today, literally today, where I started the hearing. It was a good case. And about 10 minutes into it, I got dropped. This was done by telephone, which is very unusual, but they dropped me. And the hearing reporter didn't notice it. Okay, I'm sitting there and nothing's happening. So normally I wait about 5 minutes. They call me back. Nothing happens. I call the hearing office. It was Houston. Call the hearing office in Houston. The message is our office is closed. Again, the shutdown. So what am I going to? I can't get through to anybody. I texted my client like, "Hey, I got dropped. Will you tell the judge?" He had messages turned off. So after about 20, 25 minutes, they finally figured it out. They called me back. The judge had already asked questions of the vocational witness. So the hearing was about over. He's like, well, and he's, let me tell you what the vocational witness said. And he kind of goes through. Then he says, well, I asked this question and the vocational witness gave me three jobs to answer it. However, I didn't ask the vocational witness for the DOT titles. What he was saying to me was that he was going to use another question as the basis for his decision and approve my case. That was what I was picking up. However, I can't rely on that. I couldn't assume that was the case. So I said, Judge, I hear what you're saying, but I do have some questions I need to ask the claimant and the vocational witness. So I went ahead and took another, say, 10 minutes, asked a few more questions. Wasn't ideal. And again, if I sensed the judge was going against me, I would have taken longer. But I don't want to upset the judge because he's basically telling me he's going to approve it. On the other hand, I've got to protect myself because if I didn't do that and the case gets denied, I don't have much grounds for argument. So I asked my questions. I got the vocational witness to testify. No jobs. It was based on being off task, missing too much time from work, and all that. And I'm going to I downloaded the audio already, so I'm going to listen to it next day or so. I'm thinking we're going to win, but if we don't, that would be, a reason, Angie, that I might use is that I got cut off from the hearing, and I was not there to ask questions or participate in it, and they didn't find out for 20 something minutes. And when I got back, I was sort of, the judge kind of implied, he was going to approve it. Again, I hope it doesn't come to that, but I had to kind of protect my client's interest. And even though, the judge was ready to be done with the hearing, I'm like, I don't care. I got to do what I got to do. I think he understood that. But yeah, those kind of things do happen, the technical issues. I find it just hard to believe because, they use Microsoft Teams. And I use Microsoft Teams for many purposes. And so if you have 5 people on a call and one of them drops off, it's right on your screen. You can see it. Not that hard. See that, Angie dropped off the call. Why they didn't see it. And in this case, there's only going to be 4 people on the call. Myself, the judge, the claimant, and the vocational witness. You're telling me you don't see that one of the parties has dropped off the call? But, they didn't. So that's what happened. But anyway, the appeals council is really looking for errors. And I'll give an example of an error that I recently got an appeal approved or case remanded on. During the hearing or in the decision, the judge said, I find the claimant is limited to, fine motor manipulation, using of handling and fingering and touching is limited to occasional. The hypothetical question the judge used the word frequently, not occasional. Well, the difference between the two is occasional means 1/3 of the day, frequently is 2/3 of the day. So the jobs the vocational witness gave for frequently require handling and fingering up to 5 or 6 hours in a day. They wouldn't be applicable if it was 2 hours a day. So that is grounds for appeal. That's an example of something that would be grounds for appeal. If the vocational witness or if the judge asked a question, it did not include an impairment. The claimant, let's say, has irritable bowel syndrome, and it's well documented that the person has excessive need to use the restroom, and that was not in the hypothetical. That, in my opinion, would be a reversible error because that is a factor that is well documented. And it wasn't in the hypothetical question. So there's a lot of different things. Now, the appeals council, in my experience, tends to be something of a rubber stamp, not entirely, but something of a rubber stamp. You generally find more substantial reversals more substantive reversals at the district court level. But you got to go through the appeals council. And, I would say, of the cases I appeal, and I'll tell you, I typically bring somebody in like Carl Osterhout or Brian Konoski to work with me on the district court work. Certainly, I would say of the appeals that we file, about if they're successful, not all of them are. If they're successful, about 1/3 of those are reversed and remanded by the appeals council. About 2/3 by district court. So district court is going to be probably more fertile ground for appeal. And in fact, I've talked to Carl about this, and he's like, "Yeah, I just assume the appeals council is going to rubber stamp it. I'm getting ready for federal court." So, all right, Ruben Olivio, or Olivo, I'm sorry. Good evening, Mr. Ginsberg. It's actually just Jonathan's fine. I'm 59, suffer from congenital cervical spinal stenosis. I have an appointment to go for my consultative exam. What should I expect to happen after this? Well, first of all, 59 with a significant stenosis or narrowing of the spinal canal is significant injury. So they're going to do certain neurological tests to test your strength in your arms and your neck, turning side to side, things like that. You can look up, if you go to Google and just look up the type of test used to evaluate a cervical spinal stenosis. It'll give you the standard medical tests that are used for that particular impairment. But I think that at 59 with something like that, right now the grid rules would would very likely apply. Now, I don't know about any transferable skills you might have, but one argument I would just off the top of my head would say is, okay, at 59, look at grid rule, GRID, grid rule 202.06. Go to my website, gridrules.net. Look at 202.06. It basically says a person with high school education who's got some transferable skills, but they don't transfer, who's limited to light functional capacity, is disabled. Well, if you've got congenital, which means from birth, cervical stenosis, there's a pretty good chance you're not going to be able to lift more than 20 pounds occasional. You're not going to be able to do medium work, which is 50 pounds. So I think you're going to be limited to light or sedentary just by the logical assumption based on the diagnosis. And if you're in pain or have medication side effects, any skills that may have transferred from that would be eroded. In other words, if you have chronic pain, that you're focusing on the pain, to be able to take skills you've acquired in a job and apply them to another job when you're in significant pain or you have medication side effects, not real likely to happen. Further, if you're limited to sit down or sedentary work, when they do transferable skills analysis, there's a regulation that says there needs to be minimal vocational adjustment. So, you've got a lot of arrows in the quiver, as it were, and the consultative evaluation may be enough actually to push you over the top, but certainly having your own doctor talk about the pain, your testimony about pain, medication side effects. I think that, without knowing anything more about your case, the facts that you give them make me think that you probably have a pretty good argument, because I can see a lot of arguments lining up, and judges would be, I think, mostly going to be understanding that a person with congenital cervical stenosis is going to have symptoms that are going to limit him or her to light work or less, and mitigate or reduce the capacity for any transferability of skills because, again, of pain, medication side effects, and even there could be a level of depression because being in chronic pain can do that as well. Being 58, American Made Badass says, being 58, will I get a CDR? Probably not. I think that, not to say it couldn't happen, but it's not very likely. 58 is you're getting close to retirement age. Maureen says, good evening to me and to everybody else. Good evening, Maureen. P. Brown, will I be notified medical records are requested by Social Security? No, you will not be notified. Your doctor may tell you, but Social Security doesn't notify you. In fact, the only way I know is when I look at the electronic record periodically during the case. Now that we have access to these records early, I can see if the file is being worked, and I can see when records come in. But we don't get notified when they request them or when they receive them. Papa's Place. With my back issues, when I sit or stand, my back hurts most. When I lay down, it feels better. So why in the world are the MRIs laying down so they wouldn't give an accurate reading? Well, MRI, first of all, when you sit or stand, you want to define that. How long? Sitting or standing for 5 minutes or 10 minutes or 4 hours? Because if it hurts you standing for 4 hours, that's much less of a big deal than if it hurts you after 5 minutes. Point one. So you want to be more definitive about how long. Point two is that MRIs being done, MRIs are there to show soft tissue damage, like to your spinal cord, the soft tissue discs, and so forth. It's not really to measure pain. It's to measure dysfunction or irregularities in the spinal canal or whatever part they're doing in the MRI, and it could be your foot. So it's not there to measure pain. It's there to measure, abnormality, a narrowing, bone on bone, a herniated disc, a bulging disc. And that basically says this is the diagnosis. Then, you and the doctor or the doctor has to make an assessment. Ideally, you can testify about what that means, and realize, as I mentioned before, you could have a mild disc herniation where it's kind of a, mild, extrusion, I think, extruding, or the disc material is extruding very minimally. And it could cause severe pain, or it could be, you know, a disc, you know, that is bulging and is maybe broken a little bit, broken open, so the material is coming out, and it could be moderate, quote unquote moderate, and it could cause you no pain. So, you know, there's two parts of it. Part one is the MRI show there is a problem, and part two is what is the practical implication of that problem. Now, medical science will tell you, generally speaking, if you have a severely herniated disc at L5S1 level, there's a pretty good chance that you will experience pain, and pain would be considered consistent with that type of diagnosis. However, there are people that, you know, again, have severely herniated discs that have minimal pain. Others have mildly herniated that have severe pain. There are also people that have no pathology, no herniated disc, but they have idiopathic pain. You know, it's from some other source. So, you know, you have to really flesh it out. Your doctor obviously would be a person who could offer an opinion about, you know, are you being reasonable given the diagnostic testing that's being done? But yeah, your doctor can be a real help to you by saying that the level of pain you've got is consistent with not only the objective test, but with my, you know, clinical experience with this person. And that goes a long way for Social Security. All right, Cynthia says there are 40, there are actually 85 of you on there now, 410 likes. Okay. Yeah, please give me if you like it, give me a like. I appreciate it very much. You know, we use that to help grow the channel. Okay. MT is 43, living in Georgia. Okay. Well, I'm in Georgia too. How long does recon take? I had to see the doctors they sent me. His report was I'm disabled. Can't even do sedentary work or walk without an assisted device. That is good for your case. Recon, you know, 8, 10, 12 months. I mean, that's what it's going on. It depends on if you're in the Stone Mountain office, it's going to be long. They're just really behind. But if you're in another different office, it may be less time. But yeah, it's probably going to take, I'd say, minimum of 8 months. You know, I don't normally see it longer than 12 in Georgia, but you never know. But I think if it gets, I would tell you this: you get beyond 8 or 9 months and you haven't heard anything, that's when you contact your senator, you know, Warnock or Ossoff in Georgia, and say, I need some help here. It's been, you know, 8 or 9 months. I'm not hearing anything. The doctor basically told me that his report's going to be very supportive, and you know, I'm suffering. If you can get a copy of the report, even better. If you have an attorney, you can get a copy of the report, or maybe call Social Security and say, can I come down and get a copy of that report? That would be very, very helpful, because again, you let the senator know and say, look at this report. You know, I'm going to win, but you know, they need to move things along a little bit. Hal Clayton says, with the current administration, what effects does it have the ability to get approved? I'm 60, about to follow the ability of sitting in 4 hours at a time. Right now, there's no change in terms of, you know, the rules. As I was talking at the beginning, there very well could be some significant changes, you know, released at some point. I'm hearing in December maybe, but who knows? I say the biggest impact that the current administration has is with the government shutdown. There are certain people in the Social Security Administration that are not getting paid. They're in furlough. So they're not working. So it's slowing some things down, not really case adjudication. But like I said, today I called the Houston hearing office, you know, we're closed. So obviously the people that are, you know, receptionists there are not being paid. So they don't, you know, they're not answering the phones. I've heard other people tell me the same thing. In the listserv, there was one thing going around, one story that was going around, and several people repeated it, that the attorney would call the Social Security office and say, I want a status update. We're not allowed to talk to you. We can only talk to the claimant. Totally false. That's not true. What the rule says is that in the event of a shutdown, you know, you can talk to the authorized representative, but there's certain people you can't, you know, I'm not sure you can't talk to, what you can't talk to, but it doesn't apply to attorneys. But somehow or another, in many different offices, this incorrect information was out there, and people were saying they'd be waiting on the, you know, hold for an hour and a half, finally get a hold of somebody. We can't talk to you. bunch of BS. So, I think that this shutdown has definitely impacted customer service at Social Security. Bala 2001, good evening to you. How are you doing? Template letter. Okay, RD's asking me, I mentioned this before, is I will put something on my blog. I just put something out there, by the way, on the borderline age situation, my blog at SSD Answers, which is basically a rule that says if you're 54 and 9 months, they can treat you for like 55 for the grid rule purposes. It's called the borderline age regulation. I just did a blog post about that, put it out there yesterday. But I'll put something out in the next week or so, a sample letter that you can send to your congressperson, basically telling them that, you oppose any substantive changes to Social Security disability, because the premise that it's based on that people, older being over 55, can easily adapt to jobs involving computers and involving technology. It's just not true. I mean, I grew up in an era where, I got my first computer in law school. And this was a dual floppy machine, and I was an early adopter. And so I was in law school from 1983 to 1986. And computers really didn't become a part of most law firms until the late 80s, early 90s. Someone who graduated high school in 1985 or 86 probably has very little computer skills. Even someone who graduated in the 90s, computers were not necessarily readily available even in high schools back then. So, it really wasn't until the 2000s, I think, that computers became kind of just a normal part of our lives. Well, there's a lot of people, let's say even 45 years and older, who have little to no computer skills. I know people that are my contemporaries that have no computer skills to speak of. I happen to have them. I just like the stuff. So I learn, I can, figure most things out on a computer. But my wife, who's a couple years younger than me, she can use one, but, don't ask her to figure out a new program. Don't ask her to change the default settings on something. I mean, when we upgrade, in fact, we bought a new computer for her, and I'm gonna have to go in and basically change all the programs so that they look exactly, and everything, all the icons are placed in the exact same place. She doesn't want to have to deal with anything new, and for her, that's fine. I mean, she's a workers' comp lawyer. She's focusing on her cases, doesn't want to deal with computers. But for me, I get a new computer and I got all these new programs. It's fun. I enjoy it, but I'm unique. A lot of people are not like that. Some might say I waste too much time on it. I'm dealing with a lot of AI things right now. I'm learning about that. I'm in a mastermind group about AI, and I'm using it for various things, using Notebook LM, which is a Google product, to do some pre-hearing work. And it's called a RAG, or it's closed. Our RAG, which is, I couldn't even tell you what that stands for, but basically whatever information I give it is all that it uses. Doesn't go out there, doesn't release information. The Google Notebook LM, the paid versions like that. But again, I'm learning this stuff. I like to do that. I would dare say that most people, in their 50s and 60s aren't going to be doing stuff like that. So, this notion that people, over 50 can readily adapt to new work sites, new workplaces, I just disagree. It's not true. It's just not true. And a few can, but most can't. But that's the premise they're going to change it on, I think. All right. So Jen points this out. To find out who your congressional rep is, go to senate.gov. This is to find out your senator, maybe your representatives as well. But if you're going to write a letter, you need to obviously know who they are. But that's a good bookmark to have. As far as you could always type in, who is my senator? Who is my senator? Who's my representative? And look, the other day, yesterday I went to vote, and they changed our polling place, and I'd been to both of them. I just couldn't remember which was which. So I just went to Google and typed in where do I vote, and it asked me for my address, and it gave me the place where I was to go to the polls. And I did. And I voted. Okay, Michael Chillers. Michael and I have been corresponding a little bit the last couple of days. Everyone's doing well, hanging their people. Yes, we did win at initial. We got some more work to do, Michael, as you know, which we'll follow up on. But I'm glad we were able to win initial. I really love it when I win in cases at initial and recon. It saves a lot of time, saves you money. And it's, nothing better than to get a case approved early. And, I work with there's a paralegal I've got in my office who all she does are drafts the appeals and the applications. Stephanie, I may have mentioned her before. Her mother was my paralegal for, I don't know, 20 years. And then Stephanie, did not work for me. She worked for another Social Security law firm. And then after COVID, she was working from home, and I was able to get her. And so we've kind of come up with a really good system for identifying those cases that can be approved early. She's very, very good at the wording. I've given her some wording to use, and we've been successful getting these cases approved early. Not every one of them, I can't guarantee it, but we have, I'd say, a pretty high percentage, relatively speaking, I suspect, compared to others, that we get cases approved early, which is great. Love that when that happens. Papa's Place says, thank you, Jen, and congratulations, Michael. Donald Mesa, hope I'm pronouncing that right. Diana, I'm sorry. Diana Mesa. I was told it should take about 2.5 years to get a decision for SSI. I read on my SSA account, maybe 1,200 plus days. Does that time frame seem accurate for California? I would say California tends to be slower than average. California, Texas, and Florida are the 3 slowest states that I'm aware of, that I deal with on a regular basis. I'd say, 2.5 years is probably about right. It just, it shouldn't take that long. I would tell you, Diana, after you've been waiting for 5 or 6 months, contact your U.S. senator and say, I filed this application, 7 months ago, 8 months ago. I'm not hearing anything. This is causing a lot of financial hardship. Can you find out what's going on? That is called a congressional inquiry. When Social Security offices, adjudication offices receive those, you get bumped to the front of the line. So take advantage of it. These are your elected representatives, and go ahead and use them. And again, everybody else is going to have to wait. If you can get to the front of the line, by all means, do it. Jen says, we're thrilled. Yes, we are, for Michael. Always good to get that word. And, in fact, I think this is one where they changed the onset date for maybe 3 or 4 months. And I wrote him, I said, don't mess with it. It's not worth it appealing. We're talking about appealing for 2.5 years, but this is going to change his back benefit by 1 month. Don't appeal it. Don't appeal it. Okay. There's some other issues, but Michael and I will be working on that. My Blue Moon, 57 years old, recon for a year, have an RFC from, I guess you mean psychiatric. That's not spelled right, but psychiatric and orthopedic doctors taking gabapentin, which causes what they call GABA brain, combined with TMS. I'm not sure what TMS, if that's a stimulator, maybe. Zoloft needed another shoulder surgery, herniated disc, L4-5, prior job as VP of Finance. Okay, so you've got, for a grid rule argument, you are over 55. I'm assuming you're over 55 at onset, which is helpful. You've got functional capacity forms from 2 different doctors, both mental health and physical. Presumably those help you. Gabapentin is known for causing fuzzy thinking. And you're taking medications that are going to have side effects. You need shoulder surgery. You have herniated discs. All that's looking really good. Prior job as VP of Finance. So now you have to figure out, how do you get rid of transferable skills? Because VP of Finance will have transferable skills. You're obviously a bright person, educated, and you have skills, I suspect, in terms of, spreadsheet operation, customer service, whatever they may be. But I think you could argue that the effect of the gabapentin, chronic pain, any mental health issues would erode any transferable skills. So that's the way you deal with it. You've got all the things for the grid rule kind of lined up. You just need to get rid of transferable skills. And I think the non-exertional impairments like pain, fatigue, medication side effects, depression, anxiety, those get rid of the skills. And that's how you do it. Okay. Viv says to contact your senator, check their website. Good point. Good point. They always have an inquiry form or contact form. That's how you got a congressional inquiry. Good, very good point, Viv. That's exactly what you do. Go to their website, and typically there's a button that says, I need help with a federal agency. It'll say Social Security on it. So, and of course, a lot of this is for retirement, but they have most senators. This is why we suggest that you contact a senator. Most senators have a staff person who is specifically tasked with dealing with Social Security, whether it's disability or retirement. So that's what I would do, is I'd contact your senator using the form. They're probably going to ask you for a release you have to sign. They want to see paperwork. So, look at what they're going to want. But, they can help. They can get the congressional inquiry going. No question about it. All right, so Jen's pointing out, this is back to somebody's question about this consultative evaluations. I mentioned this as well. Form 795 is a good place to do it, to put it on. Basically, you could say, I went to a consultative evaluation on, June 15, 2025. I'm reviewing the report. I would note the following concerns I have with what was said in the report. The doctor said I had no trouble getting on and off the table. This is not true. I had a great deal of difficulty getting on and off the table. I needed his help to hold me so I wouldn't fall on the floor. Doctor said no problem putting shoes and socks on. This is not true. I only wear slip-ons, and I need a long shoehorn. Whatever you would do. And this is, again, where you may want to run it past your attorney, because you don't want to come across as saying I can't do anything. You don't necessarily need to rebut every point on that report, but you can certainly, the ones that are not accurate, you could also say the doctor spent no more than 15 minutes with me. It was on his cell phone part of that time, or wasn't looking at me, did not touch me, did not do any, any sort of, didn't ding my knee, or you hit my knee to just check my reaction, anything, my reflexes, things like that. So, again, your attorney can be of help to help you make that report credible, and not like you sound like you're complaining about everything, but just the parts that are relevant. KU Thunder. Hello, Jonathan in chat. Hello, KU. Madeline says, hello, Madeline. How are you doing? Hope all is well. Madeline is a intake staffer in my office. Does a great job. Good to see you here, Madeline. We chatted today briefly. Christy Solakowski. Sokolowski. Okay, I'm sorry, Christy. I mispronounced your name. I hate when people do that to me, so I apologize to you. Sokolowski. What sources do vocational experts use for coming with job listings besides the DOT, if such exists, and why they recommend jobs that may no longer exist? Very good question. There are a number of resources. There's programs. There's one called Job Browser Pro. Again, there's other resources, selected characteristics of jobs. There's a bunch of them out there that they can use. In fact, Social Security, there's a ruling. I can't remember I think I know what it is. I'm not going to say it, but basically talked about this very issue, that vocational witnesses have to use a more robust portfolio of information. Again, in my opinion, Social Security has given judges, or the courts have given judges and Social Security a bit of a pass on relying on somewhat iffy information and basically saying this is acceptable. The courts have basically said that we know it's not perfect, but it's the best we have. And unless we're going to blow up the whole system, we're going to let them use it. That's essentially the logic there, which, if you're denied because of an inaccurate listing, not going to make you feel a lot better, but the courts have given Social Security a certain amount of leeway. As far as jobs that don't exist, two answers to that. There have been emergency messages that have come out that say that have identified specific jobs. Surveillance system monitor is one of them. There's other ones out there that vocational witnesses are not going to be able to use unless they have personal information that this job exists in numbers that are significant. And that's part of it as well. If I've had vocational witnesses testify, okay, the judge says, give me an example of a sedentary job the judge will give a functional capacity, list of conditions, which is what they call the residual functional capacity, and say, okay, based on this RFC, identify jobs that exist. And they'll come up with a job. And how many of those jobs exist? Oh, there are 48 in the whole country. Well, I would argue, I think successfully, that is not a significant number of jobs in the economy. So not only do the jobs have to exist and not be on that list of forbidden jobs, but that there have to be enough at a certain number to, be noteworthy. Because, if there are only 48 jobs of being a, whale skinner, let's say, it's not real likely you're going to get one. I actually saw an interesting article on the listserv today where somebody talked about, that within a certain job category, there was thousands and thousands of jobs, but that a claimant can only do, or a hypothetical person can only do, 2% of those jobs because of all the limitations. Well, 2% of, 500,000 is not that many jobs. And it also, his point was in the article was that if you've got, I think he came up with it, only 1 out of 20 of these jobs would really exist. Well, you're telling somebody to look for a job and you're going to say you're going to apply to 20 different employers, only 1 would even give you an interview. Is that really significant numbers? Probably not. So again, big picture here is that I think they've tried to move them away from jobs that don't really exist. I've never heard anybody use typewriter repairman or microfiche operator, things like that. Or even surveillance system monitor, although I did have that come up in a hearing the other day. But that used to be a real common one. That's no longer there. So my answer to you is that the courts have given Social Security a bit of a pass on how they come up with the job numbers and the jobs that they use. Whether that will continue if the standards get tightened, I don't know. There are some lawyers who they make a career out of this, of challenging vocational witness testimony. There's a well-known lawyer in the Social Security community, Larry Rolfing. He's in California Social Security Disability Attorney.com, I think is his blog. And he goes, if you look at the articles, he talks about, all of the inconsistencies with the different, job sources and the testimony. Again, big picture is his argument is essentially that there is no way for anybody to really know how many jobs exist, and that vocational witness testimony is often internally inconsistent. And I don't disagree with that. The issue you run into is that, if you start trying to cross-examine a vocational witness on, job estimation and all that, and the resources they use, judges are going to shut you down, and they get upset. And, again, if you want to appeal and you want to win an appeal, and then you have to hope that you get a sympathetic ear in the district court. I'm kind of the opinion that, my clients want to win now. I don't want to have to try to go in with the idea that I'm going to win on an appeal 5 years from now. And, if a judge is obviously getting a little bit ticked off at my questioning, you got to kind of you have to draw your line. You got to figure out, okay, if you think you're going to lose, you may push it a little bit. One of the people in the listserv today said that the judge basically spent all the time asking, these questions, and then the attorneys started to ask questions. The judge says, we're almost out of time. I'll give you a supplemental hearing if you want. Well, supplemental hearing is going to be 6 months from now. So he basically said, this judge is going to deny this claim, offered to give me a supplemental hearing, which would be in 6 months. What do I do? Do I just kind of wrap it up and then appeal it because I think there's enough grounds for appeal? Do I ask for a supplemental? These are some difficult, I'm not saying there's any answer to it. These are some difficult issues. But to answer the question specifically here is that the job sources that they use can be questioned. It's a strategic decision whether they should be all questioned. There are some that you definitely want to question. I'm not in the camp where I make, I go in guns blazing with everything the vocational witness has to say. I just want to win. I'm not trying to make law. I'm not trying to prove anything. And, I'm trying to choose good cases. Others will choose cases, that are a little more difficult, and they want to make law. They want to, get to district court. They want to get the judge reversed. It's just a different philosophy of how you approach it. But, end of the day, we don't know how many jobs that exist for any particular occupation, and the statistics and the resources that are out there are internally inconsistent and hard to kind of reconcile. But again, Social Security is giving the district courts and appeals courts have been giving Social Security a bit of a pass on this for now. Chris H., 59-year-old heavy-duty mechanic with an aortic root aneurysm and angina. My doctor saw me that I not lift over 40 pounds, but I lift over 100 pounds daily. I've had several CT scans showing growth. What are my chances? I think they're pretty good. I think that at 59, medium work is 50 pounds. Now, 40 pounds seems like a lot to me. Maybe you talk to your doctor about whether that's realistic. Is it something you could do frequently or occasionally or once? You might want to get that, clarified a little bit. But the diagnosis you've got, you have an aneurysm, which, may or may not be symptomatic. I'm sure it's psychologically quite concerning to you. Angina, again, how frequently do you have chest pain? Are you taking nitroglycerin that gives you a massive headache? Do you have to lay down? Again, is the 40 pounds once a day, once every 2 days, or is it, 2 hours a day? The CT scan is showing the growth of the aneurysm. That's a good case to me. The big thing that would worry me is the 40-pound lifting restriction. I think that needs to be clarified a little bit. And again, I wouldn't doubt that there's some anxiety, significant anxiety with a growing aneurysm. Is this something they can deal with surgery? I don't know. But yeah, I think all in all, I think you got a pretty good case. Jen posted the gridrules.net, which we appreciate. That's if you want to look at the grid rules, it's gridrules.net is the website. Actually, let me put on here. I forgot to do this here. I've got a banner for a case evaluation. So if you are interested in a case evaluation, please click that link right there. Christina, my regular here. How are we doing, Christina? Hello from California. Okay, I think that, Diana, we've already answered that question. Christy says hello to Christina. Both of them are regulars here. As is that Scary Sherry. Hashimoto is considered a qualified medical condition. Thyroid issues, it's going to depend on the severity of it. A diagnosis does not win. So, if you've got Hashimoto's and you're being treated with thyroid hormones and you're not symptomatic, it's not going to be disabling. If it is not controllable with medications, if there's permanent damage done, you might be. So it's going to really depend on the severity and the symptoms you experience. And some of this is about the MRI. The question about was that, why did they do an MRI lying down when I feel okay lying down? I really have more pain when I'm sitting. My response was that MRIs are not there to determine your pain. It's there to determine damage to your spinal or whatever part of your body is. But 4025's point is that MRIs for sitting. So that's true. There are MRIs for, open MRIs. There's all kind of different MRI machines, but realize that the goal of the MRI is to evaluate a medical problem, not to really evaluate symptoms. Okay. Tom says, good evening. I'm not sure when your office will arrange or set up a meeting to rehearse, make sure I have everything ready. As we're hearing in January 30th. What we want to look for, Tom, is I want to make sure that the file is worked up by the hearing office. And then what I do is do a medical summary of it, and then I do a pre-hearing brief. Normally, that's going to be done in around a month prior to the hearing, because that's when everything will be kind of in and the file will be worked up. So I would say we'll be talking in January, probably not before then, though. Try to get to these things early. And but a lot of times if the file's not organized, by organized, I mean the exhibits have to be numbered. in the medical section, the F section, 1F, 2F, 3F. I need to be organized that way. So that way, when I write a brief, I can reference an MRI report and exhibit 4F, page 325. You can't do it by date, so you need to have the actual exhibit number. So that's one of the things I got to wait for. Vince in Michigan, how are you doing, Vince? One of my clients. Good to see you here. Kim says, thanks for sharing my knowledge. Absolutely. My pleasure, Kim. This is, I like to say it's good karma. I try to send good stuff out. Hopefully it comes back, but I like to share what I know because this is black box to a lot of people. And this is a great forum because you can ask your questions in real time. If I know, I'll give you an answer. If I don't know, I'll tell you I don't know the answer. But this is a good way to, to answer questions people want to have answers to. I do the videos, and which are, I've had good feedback on those. But the issue with the videos is I come up with the topic, so it may not be what you want to hear. But here you can say, hey, is it reasonable for the time frame to be this, or when am I going to hear from you? That's what this is good for. So I'm glad that you find it useful, and I'm glad to see you. I hope to see you back. RD, age discrimination for people in their 50s is real. Yeah, I mean, it is in the sense that, if you're looking for a job, and it's between a 53-year-old with had surgery and has interstitial cystitis and PTSD, and a 30-year-old with none of those things, guess who's being hired? It's not about discrimination, but employers are looking for the least amount of trouble. They don't want people that are going to miss work. They don't want to have to deal with all the issues that arise when you've got chronic medical problems. And look, I've employed people with chronic medical problems before. And yeah, it can be frustrating when somebody misses, days at a time because of a flare-up. On the other hand, people that are in their 50s many times are mature. They have, a good life background. They can bring a lot to the party. And so, you have to, it's a trade-off. It's a trade-off. If it's a physically labor-intensive job, younger person is logically your choice. If it's something more cognitive where they're thinking, observing, making decisions, then you usually want somebody with a little bit of age on them because they've lived life a little bit. But yeah, I think that certainly for physical jobs, it is harder for people that are older. And of course, in most states, many states, I mean, Georgia happens to be one, it's an at-will state, which means that you can be fired for any reason. They have to tell you. So, they could look at you and say, you're just not moving quick enough. And that's enough to fire you. I had a hearing not too long ago. My client, basically told me, because I know the reason they got rid of me was because I'm making, I've been there for a long time making, a high wage. And so they just told me I wasn't working fast enough. Well, in his state, that was a sufficient. He has no recourse. I mean, we're going to win his disability case, but he wouldn't have an age discrimination is very hard to prove unless it's literally written down or you can show a pattern. Very hard to win those cases. I don't try them, but I know people who've done ADA and age discrimination. Very, very hard to win. Okay. We the fathers. I get $1,500. Typically, if you've got two kids, they're going to get 25%, a check equal to 25% of what you got. So it's two kids, $1,500 times 0.25. That's $375. So my guess is they're going to get round numbers, $375 each. Round numbers. William, 63, lineman getting total hip replaced, getting out of bucket. The future will be a problem. Will I qualify? If that's what you've done, you're getting it out of buckets. Now look, hip replacements nowadays are, people come out of them and they really do quite well. I mean, I probably mentioned this. One of my tennis buddies is 67 now, and he had a hip replacement, I don't know, 5 years ago. He plays tennis. His replaced hip is fine. The other hip is starting to bother him now, but the replaced hip is fine. So, if your hip replacement is successful, you may or may not find it's difficult to get in and out of that bucket. But I think if you do have difficulty, and you've had a hip replacement, it's probably not inconsistent with that. But I think the presumption is that a hip replacement will get you back to pretty close to 100%. If it doesn't, you're going to need medical support to explain why. So you're assuming it's going to be difficult to get out of the bucket. Maybe it will, maybe it won't. I don't know. But, I don't think you can assume that because you've had hip replacement that it automatically follows you're going to have difficulty getting out of a bucket. Interestingly, knee replacements tend to be more fragile in terms of your future capacity. Again, I played basketball for years and years, and know many people who've gone through knee replacements, hip replacements. The knee replacement guys typically didn't come back. They're like the doctor said, that playing basketball is going to be really hard on your knees, playing tennis. It's going to reduce the lifespan of this knee replacement by 50%. You're going to be back here in 15 years. If you don't stress it, it could last you the rest of your life. A lot of these people have said, I don't want to be undergoing surgery in my 80s, so I'm just going to give up, the physical sports. Hip replacements, you don't see it as much like that. So whatever that's worth. So I think first and foremost, I hope that the hip replacement goes well for you, and that you have no symptoms when you get out. But if you do, and your doctor would agree that the hip replacement has left you without the capacity to get in and out of the buckets at 63, there's probably no transferable skills to a lighter occupation from being a lineman. If you're limited to light work, then you've got the grid rule 202.06 and you would win. So depending on how the effect of the hip replacement, I think you've got a pretty good case. Christina says, please do not forget to like, share, and subscribe, and to comment, as it helps. If it does, pardon me. Actually, speaking of basketball, this evening I went to a friend of mine's house. For years and years, I played. It was kind of a friendly pickup game. There's a guy that had an extra room in his house, and he built like let's call it a third of a court. It's about the size of, not a half court quite, but a little bit less than that. But he would have guys come over a couple of times a week, and we'd play 3-on-3 pickup basketball. It was a lot of fun, a lot of smack talking, and it really was just not real competitive. It's just kind of fun, and it's a social aspect of it. So that game, after COVID, kind of dissipated, and then one of the guys who played in the game just turned 80 years old. And he's still going strong. I'm in a book club with him, really funny guy, nice guy. So he decided to have a little get together with all the guys from the old, pickup game at this guy's house with the court. And so we all went over there till I was there. That's why I started at 8:45 instead of 8:30. I was over there, and we went down to the court, and some of the guys played. I hadn't touched a basketball in 3 or 4 years, and reason I don't play anymore is because it hurts my back. I can play tennis, but I can't basketball. So I shot a couple of shots and made a couple of baskets, showed I could still do it. But a bunch of the guys played, and the 80-year-old, in fact, he had T-shirts, man. I've got it around here someplace. It's like I wanted to, basically the T-shirt says, "Yes, I played into my 80s," and so it was really kind of fun. He had little cupcakes and a bunch of guys who had a nice picture with it. It was very fun to see all the guys, because like I said, for years I was kind of a regular over there. Go over there, we just play pickup and just chat and so forth. And this is in addition to a regular league. But my point is that there are a couple of guys there that with hip replacements that were able to play, and the couple of guys with knee replacements were not. And this isn't a really, really low key, friendly kind of game, but. Since I was talking basketball, I made a mention of that. Do I take clients? Yes, I do. I do, because hearings are done by video. I had a hearing today. I mentioned out of Houston, Texas. I'm in Atlanta. I've got one tomorrow. I think it's in Maryland. So it doesn't matter, because it's all done by telephone or by video. So yes, I take clients in Nevada, and if you're interested, see that form down there, the contact Jonathan 3, click on that and send me an email or fill out the form. Okay, Chris says, thank you. Please call me Jonathan. Mr. Ginsberg is just too darn formal, and I'm not that way. So Jonathan's fine. SA, been going through lumbar physical therapy, have no success. Pain control, not doing too much. The physical therapist wrote that POC was being maintained on the medical record, plan of care. Again, this is where that Form 795 might be helpful. You can make your own comments about what your pain control is and about your functionality, and compared to what the physical therapist says. Because really, the physical therapist has a bias. They are getting paid to make you better. And so, if you come back and say, I'm not better, you're basically saying to them, you're not doing your job. And in a worst case, that you could be negligent in doing your job. So yeah, there's going to be a incentive for doctors and physical therapists to basically say that things are going well, maybe better than they are. Jen posted, this is how to get a case evaluation. I have that in the crawl now, but that's how you do it. And please do so if you're interested. Chill mode. My research indicates that SIC may presume I have transferable skills, former revenue supervisor and an MBA, despite having 55 of the functional limitations due to stenosis. In the last 4 years, I've had a fusion, two lumbar fusions, 8 knee surgeries, chronic pain, headaches, lumbar pain, and so forth. All right, so again, you may have transferable skills. And again, if you were a revenue supervisor, you have an MBA, you probably have transferable skills. And if you look at the Dictionary of Occupational Titles, for example, at occupationalinfo.org, and you type in revenue supervisors, it's probably an SVP 7 job. And what that means is that it's skilled. SVP 1 and 2 are unskilled, 3, 4 are semi-skilled, 5 and above, I think, are skilled. So, a revenue supervisor is probably a skilled job. You may have transferable skills to supervising people, to doing calculations, to making assessments, whatever it may be. You've got an MBA, so you obviously have, intelligence and knowledge about things. So what you would argue here is the grid rule applies because any skills that you may have been reduced or eroded, is the word I use, eroded, due to chronic pain, medication side effects, things like that. Because, judges will accept the fact that, a person, you could have all the skills in the world, but if you are in severe pain, 3 or 4 hours a day that you've got to lie down because the medication knocks you out, you're in gabapentin and you've got GABA brain, you're going to be off task. Again, in my hearing today, the claimant had transferable skills, but missing 2 or more days of work per month, being off task 15% of the day or more was excessive. So despite the fact that he had transferable skills, his reliability would be a problem. You could also argue that his skills would be eroded by chronic pain. So that's what I would do here, chill mode. I think that you can meet the grid rule. And of course, when you make your argument or your attorney makes an argument, you can argue the grid rule, again, probably 202.06, or you can argue functional capacity. You could argue the listing as well, but most people don't qualify into the listing at the hearing level. You could argue functional capacity, where you basically say that my capacity to be a reliable employee has been so reduced by my symptoms that I would not be able to get through a workday without excessive absences or off-task behavior. In other words, your residual functional capacity is less than sedentary. It's less than what would be required by a simple entry-level sit-down type of job. And what's interesting to me is that when I look at hearing decisions, and in my brief, I will make both of those arguments. I'll say the claimant, first I will say the claimant's functional capacity is less than sedentary. Then I will say in the alternative, we would ask the court to consider grid rule 202.06 or 201.06, depending on light or sedentary, and the PALMS regulation about transferability of skills. But when I see my decisions, rarely, believe it or not, do judges make the decision based on the grid rules. Most of the time, they make it on a functional capacity, and then they'll say, however, if this functional capacity assessment is, too extreme, the claimant still, even if they have the capacity for light work or for sedentary work, the grid rule will disable them. So the grids typically are a secondary justification for an approval as opposed to the primary. Not always, but I'd say 85% of the time, which again says to me that if we have new laws, new rules, it's probably not going to be as big of a deal for people over 55 because judges aren't really using the grid rule that much, directly. They're using it kind of as an indirect secondary backup to approving. Okay. Falling star catcher, it's impossible to speculate how long you'll think before age is removed. I talked about this at the very beginning. What I'm hearing is that we can expect a proposal at some point before the end of the year, maybe, could be after the first of the year. Then it will be put out for public comment, probably for 2 or 3 months. And then it will be either modified or finalized. So, let's just say that it's put out in December and that the regulation after public comment is finalized, April 1 or May 1. It will probably be then, it will go into effect probably September 1 or October 1, or maybe January 1 of 2027. I think that to get ready for it, Social Security is going to have to do something about the sort of dysfunctional job analysis data sources like the Dictionary of Occupational Titles. I think that forms are going to have to be redone because, again, a lot of the questions are being asked are presumed they're asked because the grid rules apply or age is a factor. They're going to have to redo the forms. That all takes time. If Congress, if there are, changes politically in terms of Congress, that could slow it down. There may be lawsuits. Again, I think worst case scenario would be looking at September, October of 26. It could be a lot longer than that, but that's my guess. I mean, don't hold me to it, but I think, September, October of 26 is probably, if it's going to happen, that's when it'll go into effect. Now, will it be in effect for cases filed after that date or cases adjudicated after that date? I don't know. I would think it would be for cases adjudicated after that date. So if let's say that the cutoff date is September 1, if you have a hearing in August, you're going to be in better shape than having a hearing in September, probably. So we'll see. We'll see. Chill mode. Okay, so this is chill mode. We'd already answered that question. Okay. Okay, here. Bella Italian. Chris H. Compassionate allowance. That's what the aneurysm. You have to look to see what the rules for compassionate allowance say about that. Again, I don't know. I mean, I would have to look to see. I'm sure, criteria, and the compassionate allowances, by the way, are a function of the listing. I don't know. Let me take a quick look and see if I can tell you listing if there's anything about. I'm just going to look in the cardiovascular system. All right, 4.10 talks about an aneurysm of the aorta, major branches due to any cause, not controlled by treatment, demonstrated by acceptable imaging with dissection, which means it's advanced, not controlled by prescribed treatment. So, would your doctor say that you meet the listing at 4.10? And again, go to metalisting.com, find the listings, and then look at listing 4.10. Take it to your doctor and ask. You may not be there yet. I don't know. May not be there yet. Bella Italian is a surgical nurse. And again, I think you should definitely look at that. We could look at the compassionate allowance as well. But I'm not sure that your aneurysm we don't know how large it's gotten. Is it at a listing level, or would a judge or Social Security give you the benefit of the doubt saying, if it's growing at this percent a year, the likelihood is it's going to be at this point? I kind of sense that you're not at a listing level, but maybe the combined effect of the aneurysm and the symptoms, the chest pain, the angina, plus the psychological issues, maybe some med side effects, might be enough to conclude that your functional capacity is less than sedentary, or that you meet the grid rule because of inability to do exertional work. Already answered that one. Okay, so Bella is a surgical nurse, and she's basically confirming what I said, is that hip replacements are cause less long-term or recovery than knee replacements. Adam says, I'm about to go back to work. I don't think I can make it to my decision. Is there any chance? Well, if you've been out for a year, you can make it a closed period. If you've not been out for a year, you can't, and your case will be over. So if you've been waiting for 11 months, you can hang on it one more month. You now have a closed period. You get a lump sum, but you have to have 12 consecutive months. So that's what I would tell you. We, the fathers, say thank you. You're welcome. We, the fathers. Thanks, Bella. Okay. It's not easy working and not feeling well. Amen to that. Bella makes a very, very good point that if you're not feeling well, the ability to focus, concentrate, perform quickly, reliably is impaired. And, anybody who's gone to work with even a bad cold or the flu, you're not productive. Everything's just, you have a headache and you're slower. Imagine that week after week, month after month, because of some medical problem. You have an email you can send a question to. Best way to reach me is this form, the Contact Jonathan. You can email me if you wanted, ssdanswers123@gmail.com. Pat, yes, we do have a hearing tomorrow at 12. Did not feel the link for the hearing. Yes, can you send you? I will do so. I will do so. Let me see if I've got it right here, because I do have it. I'm surprised I didn't send it to you, but okay, they didn't. Okay, let me just go ahead and do that while I'm here. So here we have, folks, real-time service. How about that? Service from the lawyer in real time. Let me do this for you, Pat. Why are you not my system here? Let's try the other email. That's really weird. Okay. All right, Pat, you know what? Rather than sit here and try to find it, I'm just going to leave it up. I don't know why you're not in there, because I emailed you before. Let's just try one more thing. Here you are. Okay. Let me just reply to that. I don't know why I must not have put you in my system. Okay. I just sent it to you, and I'll put you back in the system. I just sent you the link. So there you go, folks. Service with a smile. We have a hearing tomorrow, and we will be ready. I thought the brief turned out really well. I think we got a good argument at noon tomorrow. So, Pat, I will see you at noon tomorrow, because it's a video hearing. Chill mode. Exactly. Gabapentin, another pain meds, still pain management, functional capacity therapist says I'm less than sedentary. That's great. That is great. That's what you want. Documented interstitial cystitis, very painful condition. Anytime first of all, it causes urinary urgency and frequency and very painful urination. So wakes you up, I'm sure. But yeah, this is that's significant, very significant. I've won a lot of cases on interstitial cystitis. Racing Crate, new client, saw the 693 yesterday. Been watching in Wednesdays. There's a question or two. Very much okay. And then just reach out to me using the portal is a good way to do it, or you can email me ssdanswers123@gmail.com, and I shall get back to you. Okay. How long for the hearing? 2 to 4 weeks, typically. Sometimes not that long, but 2 to 4 weeks. I use a service called Chronicle, which I'm looking at right now, and it tells me whenever a decision comes in. And I've been getting them sometimes literally within a week or two. Other ones are taking longer. Again, the shutdown, I think, is delaying things a little bit. Um, Falling Star Catcher, thank you for your in-depth knowledge, straight answers. Go back to watch what I missed. Okay, and one of the things I'm doing is I've got somebody who's going to be sort of chopping up these videos because they're 2 hours long. It's a long time to watch, and to try to make individual videos out of them. So we're going to get some of those on the channel. It's a lot of work. I mean, to take the videos, chop them up, package them. Somebody's got to listen to the whole thing and all that, but I've got somebody who's doing that now. So I'm hoping I can get more of these out as bite-sized chunks, both on the Instagram as well as on YouTube. Speaking of Instagram, I have a new Instagram channel I'm trying to grow. So there it is, Ginsberg Law Offices, Instagram.com/Ginsberg Law Offices. So if you are inclined to do so, please go there and subscribe to it. I'm hoping I can make that a nice place I can put content, short form content, minute and a half type of things. And obviously, I hope it's going to be something that people will find useful. It'll be good for me, good for you, and that's what you want. Okay, let's see what we got here. Okay, research. New client, how long? Okay, go back, watch. Okay, that's what I was just answering. It's going to be chopped up, hopefully. It will be. We're working on it. How damaging these reports be? Obviously, unable to get me to ride the bike or really anything besides hang onto the bars, lifting my leg. This is bothering no end. Yeah, they can be damaging. I mean, the consultative reports, I mean, when they got rid of the treating source rule, Social Security basically says to the judges, you can use a consultative exam report as the basis for denial. So absolutely, it can be a problem. My experience has been most judges will see a treating source as being a more valuable resource, but they can use them. And yeah, if that's all you've got, that's not good. But I've seen, especially judges who have low approval rates who don't want to approve anybody, they look at that consultative and say, well, says you've got all this functional capacity. And yeah, it can be a problem. It can be a problem. Hopefully it won't be, but it can be. RD says, my doctor will not put a lifting restriction on your medical records. They have noticed lifting 10 pounds has caused pain. Yeah, this is a problem because, some doctors don't want to get into the functional capacity evaluation business, and I get that. A costly solution would be to go to a physical therapist and have a formal functional capacity assessment done. 2 days where you're doing all kind of exercises and work and things like that. But it may cost you $800. That's the problem with that. The other thing is you could do like a pain journal and test your capacity. A gallon of milk is 8 pounds. Get a gallon of water and try to pick it up and see what happens and how long can you hold it, and do that over a period of a couple of weeks, and then submit those test results as evidence. Say, yeah, my doctor wouldn't give me weight restrictions, so I got an 8 pound or 10 pound weight or an 8 pound gallon of water, and I lifted it, and I tried to lift it in an hour. This is how many times I could lift it. And then, after that first hour, the next hour, over the course of the day, I could lift it X number of times. And, that is evidence. And your testimony, especially if you do it over a period of time, that is evidence. Now, again, the judge could say, well, you're not trained to assess your functional capacity. But you could certainly say, I tried to lift a 10-pound bag of potatoes and they fell. Couldn't do it. I tried to lift 15-pound. I couldn't lift it up. I tried. I mean, your testimony is evidence, so you can certainly try that. And so again, if you don't want to do a formal capacity evaluation, that would be one way to do it. You could get an independent medical examination. You could find a doctor, and then go discuss with the doctor your limitations, your concerns about limitations, and see if he'll put that in a report. It's not easy when doctors won't really help you. That is definitely a problem. Definitely a problem. Am I on LinkedIn? I am on LinkedIn. Let me put my LinkedIn. I've got a LinkedIn for Ginsberg Law as well as myself personally. Let me give you my LinkedIn handle here. The adjudicator that I had on a couple weeks ago was working for the state agency, and I see that she just got a job working for an insurance company doing long-term disability. So maybe she'll come back on and she can talk a little more freely. We'll see. But she went by Linda. That's not her real name, but she went by that. But I'm glad to see, and I'll have to email her and say congratulations on the new gig. All right, here is my LinkedIn handle. It's just linkedin.com/n/Ginsberg. LinkedIn, I don't post a lot. I do have the live stream going syndicated to LinkedIn. I do post some articles there. Check who I follow, because there are some really interesting people like Adriana De La Torre is really good, information. And I'll sometimes repost some of her stuff. Carl Osterhout does some things. So, there's some value to LinkedIn. I'm going to try to use it more, but there's only so many hours in the day. And really, LinkedIn's more of a B2B. I'm more B2C, business to consumer. So I'm focused more on YouTube, Facebook, Instagram. We're even doing a little TikTok. Believe it or not, I've actually gotten some cases out of TikTok, so we're going to do a bit more of that. So LinkedIn is still there, and I still put stuff out on LinkedIn as well. Happiness, Sjogren's, RA, rheumatoid arthritis, back neuropathy, full-time employee for 18 years, journal, lots of pain. Do I apply when I can't work full-time? You want to apply, I would say big picture is when your earnings get below SGA, which in 2025 is $1,620 a month. Let me see if they've got the new numbers out for 26. SGA table. Let's see here. They may have it out yet. I don't know. I'm just going to go here. They do. So 2025 is 1620. 2026 it will be 1690. So if you are working and your earnings are below $1,620 currently, or below 1690 as of January 1, you could apply. Now, the question is, should you apply when you're still working? My experience has been, you need to almost show that you need to show a pattern that your hours steadily decreased, you're having trouble getting through the day, you're needing help from coworkers and so forth, and your earnings need to be fairly substantially below SGA. So if we're talking about 2025 and 1620, you have earnings of $1,000, $1,100, maybe even $1,200. I think you could say that's clearly not SGA. Your earnings are $1,600 and SGA is 1620. They're going to probably assume that you deliberately kept it below. So it's just a judgment call. I used to tell people, wait till you've stopped working, or you really are not working at all. I don't really say that anymore, but because I know people have to earn money to survive. But, Social Security tends to see things in black and white. So if you're either working or you're not working, and if you are working, you're earning $1,200 on a regular basis, the question a judge would ask would be, well, what if you got an easier, less physically demanding job? Could you do that at SGA level? And realize 1,620, let's multiply that, 1,620 per month gross times 12, that's $19,440 a year. You live in New York, you live in California, Chicago, can you survive on $19,000 a year? I don't think so. These numbers, in my opinion, are pretty low. So being able to earn $20,000 a year, let's say, does that make you capable of supporting yourself? It doesn't really to me. But so the answer to the question is yes, you can apply when you're earning below SGA on a consistent basis. Is it easier for the judge if you're not working at all? Yes. So that's how I went into that question. My personal physical therapist, not a CE in terms of these various tests. It just kind of depends on what the therapist will do for you. Some therapists are going to be more inclined to help you pursue disability. Others are going to say, you need to think of yourself. If they get concerned when people say, I'm going for disability, because it almost means like you've given up. Like, I know I'm disabled and pay me. So I think you need to make sure that you tell the therapist and your doctor that you hate the idea of having to pursue disability, but you have no choice. So whatever that's worth, that's what I would tell you. So if your physical personal therapist will help you, that's great. Christy notes that the FCEs with a physical therapist, the ones that are the 2 days that cost $1,000, whatever, they are rough. They are very, very rough. No question about it. Andrew, I talked to him and he was possibly going to be available for today. But I was not sure what I was going to do time-wise because I was coming from this little get together, and I'll try to get him on, if not before the end of the year, after the first of the year. But yeah, we chatted after that, and he's definitely wants to come back on. He has some really good insight. Again, Andrew does, so one-man shop, and he's a very sharp guy. He does a lot of teaching at seminars, and his insight is really good. He's a very good lawyer, and I definitely think that it was helpful. I really want to get back on is Spencer Bishens. I don't know if you saw that one, or if you can. I'm not sure when it was, or it was earlier this year. He was real. He just had a real presence about him. Spencer used to work for Social Security, very opinionated. He's got really strong opinions about the disability process. He wrote a book about it, and basically he's pretty cynical about the whole thing. But I thought there was a lot of energy in that video, that meeting. So I'm going to try to get him back on as well. The other one I thought was really interesting was I had Tricia, who was a Social Security adjudicator, and she became a psychiatrist. And I thought that was kind of interesting, her perspective on it. And she's very tuned into what Social Security wants. There's a number of other attorneys that I'm talking to. We'll get back on. We'll hopefully get some new people on as well. What is the earning? Okay, good question. What is the earnings? Actually, you know what? I've got, if you go to my website called For Social Security Disability, I'll put the link in here. And here's links to all the tables. I'm going to put that in the comments here, and I'll give you an answer to your question. So in 2025, $1,810 bought you a quarter credit. 2026, $1,890. So 1,890 times 4 is $7,560. So if you earn in a year $7,560 or more, you get all 4 credits starting in 2026. So I generally tell people, if you want to qualify for disability and you earn around $7,500, $8,000 in a year, you get all 4 of your credits for the year. So that's kind of what you should be shooting for, to try to build up those credits. Okay. RD, I'm going to appeal once I'm working after my onset date. If you are, you to tell them, if you're doing something where you're having to pay for gas or other supplies, you can reduce your gross income by cost of doing business. All right. Mark says Social Security scheduled for 2 CEs, medical, 1 psychological, went to the psych. Then they canceled the medical. Is that bad or good? Probably good. It probably means that they looked at your record and determined that there was enough there to make a decision, probably a favorable one. So I think that's probably a good thing. Yeah, Spencer, it was great you bought his book. Good. Spencer is a very interesting guy. He worked for Social Security for a number of years, and he was a decision writer. Um, let's see here. I'm getting an error here. Let me just see if I can make that go away. Look at my comments. I'm getting an error there. But anyway, Spencer, yeah, he's got a very interesting take on it. He worked for Social Security again as a decision writer. He talks about how he would argue with judges. They would say, "Oh, deny this case," and he would say, "I just listened to it. You need to approve this case," because some judges he can convince, others not so much. Very, very critical about judges that go in with the idea that they're looking to deny a claim. He thinks the whole system is designed to frustrate people, make them give up. That's his take. I don't know if I'm quite that cynical, but that's his take, and he worked there. He just says that they bank on people giving up because they will really want to protect that trust fund. And I think, I don't want to overstate that, but I think that's a real factor here. That Congress puts pressure on Social Security. It's easy to pick on disability recipients. There's no big lobby. There's no, nobody standing up and saying, these people, they vote. It's just an easy thing to pick on because, how many times you say, how many times you hear this people say, all these people collecting Social Security, they're all fraudulent. Everybody knows that there's all kind of fraud in government. And in certain areas there may be, but in Social Security, relatively speaking, it's really not a lot of fraud. It's really hard to get on. But people will sort of say that they buy the soundbite. And look, I mean, there are people you see on TV that talk about, well, if there are jobs that anybody could really do. And I agree. If you were told you have to do this job for a week, otherwise, we're going to burn your house down, most people could get through a week. But, I look at it from the perspective of, could you work this job 8 hours a day, 5 days a week, month after month? And over the course of 6 months, could you make that work? I think that's a much different question. And I think a lot of people could get through a week or two maybe, but when they get to, 6 months or 3 months or whatever, it's much more difficult to win. So that's my take. All right. Christina says, don't forget to like metal. I'm not sure what metal, yellow, first, red means. Not sure what that means, but okay. Okay. All right. So, all right, we're getting close to the end here. Any more questions? I don't see any more questions coming in. I think I've covered all the questions I've got here. So again, I think, the thing a couple of things we talked about would be the possible changes to the disability system. Okay. And P. Brown makes a comment here. I'll just mention this, people that are on disability, many times they go from making $150,000 a year and their disability is $3,000 a month. It's a big pay cut. So, but believe it or not, P. Brown, that is not a basis to claim disability. You can't say to the judge, well, there's no reason I would do this. Why would I take a big pay cut? You could say it, but that's not evidence of your disability. Evidence has got to be medical. But I think it does go to your motivation. But certainly to tell a judge, and I always tell my clients, talk about it this way, had a good job, making good money. It was personally fulfilling. I had a lot of relationships, friends, coworkers, things like that. Leaving that, I'm sitting at home for the last 2 years looking at the four walls. People have said, you don't feel like you have any self-worth anymore. It's really hard to get through the week. They just become boring and you become invisible, and your friends and your family treat you differently. Those are the sort of things I tell people to talk about. I think you want to really let the judge know, you want to paint a picture. This is just an unpleasant scenario all the way around, and not just medically, but mental health wise, because anybody who stops working after, being employed for 30, 40 years is going to be unhappy when they can't work. And it's not about they love the work. It means that they, found it fulfilling in some respect. So anyway, that's something I think that is relevant for a judge to talk about, the frustration, how you feel like you're a failure, you feel like you're a nobody, your friends and your family, you're invisible. I had somebody say the other day, I feel like I'm invisible. that, nobody reaches out to me anymore. Nobody calls me. Nobody, their job, had a job where people were always asking for advice. Nobody calls me to ask for advice. What is the purpose of going on? I have this chronic medical problem. I'm in pain. Why am I bothering? And, that's pretty tough, So anyway, all right. Well, on that happy note, let's end this. I appreciate everybody for spending your Wednesday evening with me. We will do it again next week. And again, I'm going to try to line up some guests because I think that's kind of fun to kind of go back and forth and get a different perspective. As always, if you want a case evaluation, visit me at the bit.ly, contact Jonathan3, or go to ssdanswers.com. That's my main website. I've got another one for socialsecuritydisability.com, but the SSD Answers is really a place to go. Look at the grid rules site, gridrules.net or metalisting.com. Those will be helpful resources for you, gridrules.net in particular. And then again, follow me on Instagram, follow me on YouTube. I'm going to try to get some interesting videos coming out before the end of the year. And hopefully we'll see you all next week. So again, thanks for tuning in. And I look forward to hearing from some of you if you need help from me. Thanks a lot.